It is April 3rd of 2026, and this is the Court Gallery. Welcome back, ladies and gentlemen. Today we've got a massive compilation of courtroom moments that really show the human side of courts and judges. We've got everything from tense landlord disputes with Judge Simpson, where he steps in to help terrified renters, to a strict probation hearing with Judge Lee, where the court is absolutely not buying the defendant's excuses. And also, I've got one of the more strange court cases I've ever seen, where we have a pair of attorneys trying to get a simple speeding ticket thrown out on a speedy trial motion of all things. Grab your popcorn, ladies and gentlemen. Get a drink. It all starts right now.
Good morning, everyone. Court does call the case Linden Park Apartments versus Haley Forberg and Destiny Garvin.
Hello.
All right, there's Ms. Forberg. All right, what is plaintiff's claim in this case?
Your Honor, this is a non-payment of rent case. Rent owing through the end of April is currently due in the amount of $3,600. Court costs in this matter $188.54. Total amount to retain $3788.54. No money judgment was requested.
All right, Ms. Forberg, how are you intending on getting that paid?
So we actually, it's all DJ. He's not here, I guess, but he hasn't been paying his half of rent. I haven't been then living there and I can't get in contact with him. I have been paying my half of rent, and we just sent in $2,200 that he owed from his staff just now. So it should be paid off, a lot of that. We talked to the landlord and directly paid $2,200 just a few days ago. And then
Do you have that, counsel, the 22?
It doesn't look like that hit the ledger I have yet. The last payment I'm showing was $700 on March 4th. So that'll obviously the balance will include.
All right, so there's 2,200 out there. And
yeah,
what I will do then, my next date is the 10th, is next week. All right, so I'll adjourn this out 1 week. You can contact plaintiff's counsel's office, see if you can arrange how you're going to get this paid. Is he still residing in the premises?
yeah. So I've been paying my half and I've been paying a lot of his half, but I don't know why I can't get off of this lease no matter who I call. He's not even here today, which does not seem okay that I'm the only one that has to deal with this, as we're both on the lease. And I've been paying all of his rent payments. So I just don't understand how this is still my problem. I don't understand how he's not being also held accountable.
Well,
I understand it's my problem.
Okay. I'll wait for you to finish and I'll
Sorry,
explain the question.
It's on a
The answer to
delay.
the question is you signed a contract on the lease. That's why you're still involved in this. So you're still liable for the payments that are due under that lease. The dispute as between who's paying what half and whatever, that's going to be for you two to work out. But what I will do is I'm going to adjourn this out 1 week to April 10th, 2026 at 2 p.m. That's an in-person hearing. I suggest that maybe you contact plaintiff's office if the issue is that you're not residing there, but I'm not sure what you could necessarily do in that regard. But I'll adjourn it out to that date. Okay?
Okay.
Thank you.
So how are we going to find where to go and for in-person court? Are we going to get mailed another thing?
You'll get mailed another notice, but if you look on the paperwork that you received, the paperwork that you received has the court address on it.
Okay, and what time on April 10th then?
2 p.m.
All right, April 10th at 2 p.m. I'm unable to get mail because he lives there and won't let me in, and I don't have a mail key.
All
So,
right. Do you have some place to write something down, ma'am?
yes, I can do it right here.
All right. The address is 4133 Washtenaw Avenue. And it has an Ann Arbor address. It's the same location as the Washtenaw County Sheriff's Department.
Okay. And then you
All right.
said April 10th at 2 p.m.
Yes, ma'am.
Okay, thank you very much.
Thank you. Six Trails versus Olivia Bertkey.
Joe Joseph for plaintiff.
Olivia Bertkey?
Yes, Your Honor.
Okay, there you are. Okay. All right. What is plaintiff's claim in this case?
Judge, we show run to retain through today's date of $2,663. Court costs are $172, totaling $2,835.
All right. Ma'am, how are you intending on getting that paid?
I have a money order of $400. I know it's not much, but it's better than nothing to turn into the office today. I
Okay.
plan on making a minimum of a $500 weekly payment to get caught up. But I assume on the papers that were sent via mail that we will have to evict from the premises though, if I'm correct.
Okay. I don't know what you meant by that last part, but wait.
Well, the court paper that got sent to me said, that in the name of the people of the state of Michigan, you're notified, the plaintiff has filed a complaint against you and wants to evict you from the address.
Right. Okay.
Yeah. I've never gone through this before, Your Honor, so I'm
That's okay. I can kind of tell.
okay.
I'd like to say that myself, but I've been doing this a minute.
Yeah.
Okay. So here's what happens on a non-payment case. On a non-payment case, an opportunity is being given. You're not automatically evicted. An
Okay.
opportunity. Okay. Does that help you out a little bit?
It does, yes.
Okay. Okay. So an opportunity is given for you to try to get the amount of money paid to the landlord.
Okay. That makes me
Okay.
feel a whole lot better. Okay.
Okay. Yeah, you're smiling. You're not
Yeah.
like so serious. You were scaring me for a minute.
I was scared myself. I turned all red.
Okay. I'm sure you were. All right. So you're gonna pay $400. When are you gonna get that paid, young lady?
Right after I get off this Zoom meeting, I was gonna go right
All
up to
right.
the office and turn my money order in of $400 and then make a weekly Thursday payment of a minimum of 500.
So you're gonna pay at least 500 by next Thursday?
Yes.
Okay, so that'd be the 9th. So I'm gonna put that in the file.
Okay.
So that gets you down there. And then what I will do is I'm going to adjourn this out for an in-person hearing, April 10th, 2026 at 2 p.m.
Perfect.
Okay. In the meantime, what I'm going to suggest that you do is you contact the landlord or the landlord's attorney's office to see if you can work out a payment plan. You've got something in mind that you can do. See if that will work with them. And the way that works, so you don't worry, if they do it, then they may give a consent judgment where you have the time to get everything caught up. That's one way that it's done. The preferable way is a conditional order dismissal, which would lay out the payments that you have to make. And if you don't make those payments, then you could be subject to eviction or that kind of thing. If you can't work something out, you guys come in here and then I'll work something out. We'll figure it out.
Appreciate it. Okay. I appreciate you. Okay.
Is that better?
It's much better. Thank you.
All right. Because like I said, you were stressing me out. And I don't
I
need
was
to be
stressed myself. I have a young daughter. She's sleeping right now.
You were sharing it. So okay.
Yeah, I'm
All right.
sorry. Okay.
It's okay. We'll see you next week. You have a
Okay.
wonderful, blessed weekend. All right.
You as well. Happy Easter.
Yes, ma'am.
Bye.
Six Trails versus Denise Jones.
Joe Joseph for plaintiff.
Say not.
Not, and I have a service in jail.
You have service in JIS. All right. Denise Johnson, not here. You may proceed.
Thank you, Judge. At this time, we would move the court for entry of a default judgment possession only. We show rent retained through today's date of $2,757 plus court costs of $172. That totals $29.29 with a writ date of April 13th. That's my information, knowledge, and belief that defendant's not a minor in the active military or otherwise incompetent, and the property's been kept fit for habitability, its intended use, and complies with all state and local laws.
Judgment to the plaintiff. That is by default for possession. Redemption amount, any amount requested. Writ to issue in 10 days. Arbor House versus Tanisha Hinton. That matters dismissed on plaintiff's motion without prejudice. I think that's it for you, sir.
It is, Judge. Thanks so much. Have a great weekend.
You do the same.
Thank you.
Peninsular Place versus Jordan Bell.
Good morning, Your Honor. Rebecca Austin for plaintiff.
Jordan Bell. There is no response. You raise your right hand. I'll let you proceed. Solemnly swear or affirm. Testimony you're about to give will be the truth, whole truth, nothing but the truth, so help you God.
I do, Your Honor.
All right, go ahead.
Honor request of possession, only default judgment, rents retained is $672.27, court cost of $177.72 for a total judgment of $909.99. On information and belief, Mr. Bell is over the age of 18, not in active military service, not incompetent, and the premises were kept in the use intended.
Judgment to the plaintiff. That is by default for possession. Redemption amount is any amount requested with the writ to issue in 10 days.
Your Honor.
Thank you. Peninsular Place versus Raya Hill.
Rebecca Austin for plaintiff, Your Honor. That case is going to be dismissed on plaintiff's motion, please.
That case is dismissed on plaintiff's motion without prejudice. Court does call the case of Peninsular Place versus Laura Goodwin.
Rebecca Austin for plaintiff, Your Honor.
Hello, I am here.
Ms. Goodwin?
Hello.
Hello. I don't know why she's not showing up on my screen. Yeah, could you say hello again?
Hi.
Ran into the queue. Oh, there you are. Okay, hello.
Hi.
Hi. All right. What is plaintiff's claim in this case?
Your Honor, this is a non-payment of rent case. There's currently past due rent in the amount of $930.48, court cost of $177.72, for a total of $1,108.20, and you should have a proposed consent judgment hopefully in your file.
I do. However, I don't know that I can enter it on this first date because she doesn't have counsel. All right, Ms. Goodwin?
Yes. Yes.
All right. Basically, you guys have entered into a consent judgment
Yes.
as to how you're going to pay this.
Yes.
Okay, so here's what I'm going to do. I can't enter this on the first date because you don't have counsel present. All right.
Okay.
So what I'm going to do is I'm going to adjourn this to April 10th, 2026 at 2 p.m. Okay, that normally is an in-person hearing, but what I will, and I'll let my staff know, we'll let you appear via Zoom since you guys have worked this out, and then I can enter that judgment on that date. Okay.
Okay, you said I need like I'm assuming representation.
Well, I can't enter it because you don't have an attorney at this first hearing.
Okay, so
Okay.
the same, I'm sorry, I'm at work, I apologize for about this. But so the same, I heard you say something else to someone else regarding getting one and contacting one. Is that the same procedures and precautions that I need to take as well?
In terms of contacting the attorney's office,
Yes.
you can do that if you'd like, but it looks like you guys have already worked this out.
Yeah, we have. Like I have like
Okay.
I apologize. Go
Oh.
ahead.
No, it's okay. You guys have already worked this out. I just can't because you don't have an attorney. I can't enter this judgment today.
Okay. So do I need to get an attorney myself is my question.
Okay. Oh, right. You can if you want, but you don't have to.
Okay, well, cool. If I don't have to and that everything will be fixed on the 10th, then I'm okay with that.
You're okay with that?
Yeah, I'm all right.
Okay. All right. What, you don't like attorneys?
No, it's not like that.
No, I'm kidding. I'm kidding. I'm kidding.
I
You
just
don't have
figured
to answer
because
that.
like everything was kind of figured out before I got here that it would be kind of like a smooth sailing situation. So that's kind of why I didn't know if I needed one or not.
No, it looks like when I look it over, it looks like it's good. You guys have worked it all out. I just can't do anything today on it.
Oh, of course, I understand.
Okay.
Yes.
All right. You take care. Have a great weekend.
You too. Thank you. Bye-bye.
Bye-bye. Court calls the case of Peninsula Place versus Jeremy Jackson.
Good morning, Your Honor. Rebecca Austin for plaintiff.
Hello.
My screen is not working, but Mr. Jackson, say your name again, please.
Jeremy Jackson.
Gotcha. Okay. All right. What is plaintiff's claim in this case?
Payment of rent case, Your Honor. Mr. Jackson currently owes $718.48. It looks like he essentially owes April rent.
That total amount is how much, counsel?
$18.48.
You broke up on me. It's okay. Just give me the number again, please.
71848.
Got it. Okay, that's what I thought. All right, Mr. Jackson, how are you going to get that paid?
I'm actually not sure where that figure came from, as my rent is only $624 per month. But I just paid April's rent this month. I mean, not this month, today, as of this morning before the hearing.
Okay, so probably what you have is you have your rental amount plus court costs.
I paid the court cost. The court cost would have been from March's rent. I paid the entirety of March's rent as well as the court costs. Because the judgment is for March, not April.
No, we're in April. So
no,
April is now included, sir.
Oh, I understand that, but they filed before April, is what I'm saying. They filed in March.
I understand that.
So,
but whatever rent comes due, they're entitled to a judgment for. So since we're past April 1st, they're entitled to take a judgment for April rent.
I'm not quite.
Counsel, did you pardon?
I don't quite understand how that works.
Okay. So if they file in the middle of March and you owe March, if you don't get everything paid before we get to April or the court date comes to April, then they're entitled to, let's say you paid nothing. They're entitled to go after March and April.
Okay. But if
Counsel, go ahead. What, sir?
If I paid the balance before April, then does that make a difference or?
Well, it could, but I don't know if that happened in this case.
Rent was paid in full by March 27th.
Do you see that? Do you see that?
I do, Your Honor. It looks like he was down to a zero balance at the end of March, but then because of the court date being in April, they added April rent on and kept him in court.
Well, then you can't do that. Although he was saying it wrong, you can't do that. The judgment could go for that if he owed something as of the end of March, but he didn't. So he's paid through. So effectively, this matter has to be dismissed.
We'll dismiss it then, Your Honor.
Case is dismissed. That's without prejudice. Thank you, sir.
Thank you.
Court calls the case of Peninsula Place versus Camille Cox.
Morning, Your Honor. Awesome for plaintiff.
Hi, I'm here.
Okay. Need a camera if you have it. Oh, there you are. Okay. How much is owing?
Your Honor, with court costs.
I don't know where 8 come from.
Hold on a second. Did she get down to a zero balance by the end of March?
You did, Your Honor. Would you like me to dismiss this?
She did? Okay. Ms. Cox, it's your lucky day. Case is dismissed.
Okay, thank you.
All right. Okay. Have a good weekend.
Thank you, you too.
Peninsula Place versus, is it Zari Goss?
Rebecca Austin for plaintiff, Your Honor.
Zari Goss? You may proceed.
Your Honor, to request a default judgment for possession only, rent to retain $1,171.67. Court cost of $177.72 for a balance of $1,349.39. Upon information, believe Ms. Goss is over the age of 18, not in active military service, not incompetent, and these premises are kept fit for the use intended.
All right. Judgment to the plaintiff by default for possession, redemption amount in the amount requested, writ issue in 10 days.
Thank you, Your Honor.
Peninsula Place versus Jonathan Weathers.
Good morning, Your Honor. Rebecca Austin.
I'm here.
Jonathan Weathers.
I'm here. You hear me?
Okay. Yep, we can hear you, sir. All right. Plaintiff, what's plaintiff's claim in this case?
This is a non-payment of rent case. Total due is $914.72. And you do also have a proposed consent judgment that I understand will have to get entered next week.
Yes. All right. Sir, you guys have entered into a consent judgment. I can't do anything with it today. So I'm going to have to adjourn this out. I have to adjourn it out to April 10th, 2026 at 2 p.m. That's an in-person hearing. But I would permit, since you guys have already worked it out, for you guys to appear via Zoom, for you to appear via Zoom, so that we can just put that on the record. Okay, sir?
Okay. Well, what time is the Zoom? What time does the Zoom call be? Because I gotta be at work on that day.
It'll be at 2 o'clock.
Okay. I'll try to make sure I can be in there, and I'll make an arrangement or something like that. Come in, I can make it on there.
Okay. Very good. All right. Thank you, sir.
Yep. Have a nice day now. Take care.
All right. Peninsula Place versus Andreas Smith Jr.
Good morning, Your Honor. Rebecca Austin for plaintiff. Your Honor, we're going to dismiss this case. It's paid in full.
Case is dismissed on plaintiff's motion without prejudice. Peninsula Place versus Danae Martin.
Good morning, Your Honor. Rebecca Austin for plaintiff.
Hi, good morning.
Good morning. You didn't come to my screen, so can you try that again for me?
Oh, yep, sorry. Good morning.
Why? I don't know why it's doing what it's doing. Anyway. All right.
She has that black little hat.
I know where she is. All right. What is plaintiff's claim?
This is a non-payment of rent case. There's currently past due rent of $1,635.22. Court cost of $177.72 for a judgment of $1,812.94.
All right. So Martin, how are you going to get that paid? Let me put it that way.
I was also gonna request to do a payment plan. I start working next week and I would get paid weekly, but I wouldn't get paid until the week after that, which is technically not for another 2 weeks. So I would need to get in contact with someone about that to try to make weekly payments that way.
Okay.
Be able to pay that balance off, if that's okay.
Okay, I got you. Here's what the first thing that I'm going to do is I'm going to adjourn your case 1 week out to April 10th, 2026 at 2 p.m. That's an in-person hearing.
Okay.
What I'm going to suggest that you do is contact the attorney's office or, oh, there she is, Holly. Holly's here.
Okay.
So she loves talking to people, that apparently. So contact Holly, go down to the office and see if you guys can work something out. All right, Miss Martin?
Okay. Thank you.
All right, we'll see you next week. Take care.
You too.
Peninsula Place versus Jada, is it Shirar?
Yes, Your Honor.
Good morning, Your Honor. Rebecca Austin for plaintiff.
Now they're back on this screen. All right, what is plaintiff's claim?
Rent's a non-payment of rent case. There's currently past due rent of $1,154.67, court cost of $75 for a total of $1,229.67.
All right, ma'am, how are you going to get that paid?
So I paid my March rent on March 18th. When they put a 7-day quit or pay my rent, I am going through a financial hardship right now. My checks are getting garnished and they taking like $400 each of my check. So I originally tried to pay my rent on time. I ended up paying $500 on the first. I ended up paying like $300 on the 13th, and originally everything was due on the 18th. They filed, I got basically like a court of $102 payment, which was paid on March 21st. My March rent is paid in full with the court
Okay.
fee. I only owe April, and my
Hold on,
April.
Ms. Shirar. Ms. Shirar, hold on. Hold on. All right. No, you're trying to tell me a lot. Just take a breath for a minute, okay? All right. Here's the deal. Trust me on this. I'm not letting anything happen to you I'm just not letting anything happen. So just take a breath for a minute. I know you're trying to tell me everything, but let me ask this, counsel. Did she have all of her March rent paid by?
She did, Your Honor. We will dismiss this case.
All right. See, Ms. Shirar? I think I knew that's where you were trying to head. So this case is going to be dismissed.
Okay, thank you.
You're welcome. You'll make a good lawyer one day. Yeah. All right. Have a good weekend.
You too.
All right. Peninsula Place versus Jomar Pie.
Good morning, Your Honor. Rebecca Austin for plaintiff.
Hey, how you doing?
Okay. I don't know why this is acting this way. It should come right to my screen. State your name again, sir. Oh, there you are. Never mind, I found you. All right. You guys have worked out a consent judgment, but I can't enter it today. All right, sir?
Yeah,
So you're unrepresented by counsel.
I was in the positive before.
I'm sorry?
I said, I only owe April rent. I was in the positive before this.
He was, Your Honor, also at a zero balance at the end of the month, so we'll dismiss if you'd like.
Okay. So we'll dismiss your case, sir, okay?
Appreciate it.
All right, take care. Have a good weekend. Silo Farms versus Travis Okerman and Nicole Meltzer.
Good morning, Your Honor. Rachel Dornbush, Pallets Law, on behalf of the plaintiff.
And I think they're here. You'll need to unmute, folks. Can you get yourself unmuted? You look like you're trying to talk to me, but I can't hear you. Oh, there you go. Try again. I still can't hear you. No, we're still not hearing you. Do you?
Yes, sorry, Your Honor. Can you hear us okay
You got
now?
it?
Yeah,
Yeah.
new computer.
New computer, some new problems as well that came with it.
No, it wasn't. Travis broke it, and Nicole fixed it. That's what happened. I got it. I saw the whole thing.
These types of 6-7 months. Yeah.
Okay. All right. What is plaintiff's claim in this case?
With costs, Your Honor, $2,486.95.
All right. Folks, how are you intending on getting that paid?
Your Honor, we have paid as of March 26th, $1,000 towards the demand for possession and complaint. Today we will be paying an additional $700 as soon as this hearing adjourns. With both adults' income currently being tied to workers' compensation, based on that income and the pursuit of financial assistance, we are confident that we can cure the full balance within approximately 30 days with a plan. Yes.
Okay, I don't know what all that means. So hang on a quick second. Do we have the 1,000 on their account already?
Let me take a look, Your Honor. I suspect the answer to that is yes, we do, Your Honor.
You do. Okay.
Yeah.
So you're gonna pay 700.
Correct.
Okay. Now, are you seeking financial assistance of some type?
Yes, sir. I was looking into getting a personal loan this morning. I do not believe we qualify for any like state assistance. I do believe we make too much money to collectively, but due to us both going out on workman's comp, our incomes have been just reduced temporarily.
Right. I got you. So have you contacted Hawk at all?
I looked at the Hawk form and it looked like we made too much money. I can still apply. I just wasn't sure if I would.
Okay. I'll tell you what. Why don't you apply?
Okay.
And the worst thing they can do is tell you no, right? Better
Yes, sir.
than guessing. Okay.
Yes.
So you apply, get the 700 in,
Mm-hmm.
and then how were you intending on getting the rest of that taken care of?
So we get another round of checks in 2 weeks. So we're planning on
By
making
4/17, we would make an additional payment. We would try for around $1,000. The following week, we would be hoping to put in at least a couple $100. I know that's not much. And then by 5/1, May 1st, our intention is to have the balance paid off in full.
Okay, I got you. Okay, so you got a plan in mind. Here's what I'm going to do. I'm going to adjourn this to the 10th, 2026 at 3 p.m. That's an in-person hearing, folks, okay? Once you apply for Hawk, if they don't give you an answer right away or whatever, or you apply for other type of assistance, there's a form in your packet called a rental assistance form. You'll need to fill that out, get that to the court by Wednesday. Okay?
Okay.
I would suggest in the interim that you contact either your landlord or Ms. Dornbush, see if they can work something out with you to kind of structure that payment that you have and kind of just set that in place and let you guys go about getting this solved. Okay?
That's
Thank
great.
you, Your Honor.
All right. Fantastic. And we'll see you next week.
Okay.
Thank
Thank you,
you.
sir.
Thank you. Have a good weekend.
You as well. Thank you.
Did I? These are all. Okay. Okay. Sile Farms versus Stephanie Vogel. Hello, Miss Vogel. And Corey Vogel. Okay.
Corey's
All right,
not
we've
here
got-
'cause he hasn't been in the home since July.
Gotcha. Okay. So what is plaintiff's claim in this case?
Your Honor, with court costs is $3,610.79. Your Honor, I just wanted to let the court know that Ms. Vogel did reach out asking for amended pleadings to be filed. I don't know if this is something she got directly from an agency that she's applied with or based on her own assessment. Your Honor, the paid through date is calculated based on the base rent and other static charges, but there are some charges that are done based on usage. And so if the total due exceeds 1 month rent, it backdates the paid through date through the prior month. So
Got it.
based off of that, what's on the paperwork is accurate from that calculation, but it may not show subsequent, it may not account for additional payments that have been made. And so I believe that Ms. Vogel should be able to take her pleadings and a copy of her ledger showing additional amounts that have been paid which should hopefully address that issue. But if the court requires me to submit something additional, then I defer to the court on that.
To do that. Okay. Okay, so Ms. Vogel, you said you needed an amendment. What's going on?
So they said that I've only paid through December 25, and my ledger says to 10/26, which would be my January rent I paid because I'm a month behind. And when I turned this paperwork in, when I spoke to somebody on the phone, they said that because the dates are not adding up, I needed to have something different. That was through DHS. And I haven't heard, I haven't gotten a letter back neither.
Hold on. Who were you talking to that told you that?
It was a case manager. She was all confused. It was very strange because she didn't have my case information even right. So I'm just
Okay,
waiting.
hold on. Who, there's a case manager through who?
DHS.
DHS? Okay.
Mm-hmm.
I'm not sure what that is. I would go back and try again, ma'am, because that's not a problem we run into. They should understand how things are calculated and shouldn't be giving you the runaround based upon that.
Well, the ledger says I'm
Okay.
paid through January, so this is saying I'm only paid through December. That's what the discrepancy is.
Right, and it's going to read that way based upon a per diem calculation. But they can go by the basically by the ledger is what they can go by.
But the ledger is saying I'm paid through. That's what I'm telling you.
All right. Ma'am, I don't know that the amended complaint is going to solve the problem. This is a DHS problem more than it is a plaintiff's problem or even your problem. They just need to do the math and indicate whether or not they're going to assist you. So let me ask you this, Ms. Vogel. How many people are in your household now?
3.
Okay. So of this balance, so that you know, the most that DHS is going to pay is $620.
Okay.
Okay, so that you know that. Have you applied through Hawk?
No, I didn't know that I could do that without a letter from DHS stating that they would pay a certain amount.
No. You need to go ahead and apply through Hawk.
Okay.
And Your Honor, if I may
Okay.
just add, I just went ahead and did a comparison based off of the balance that was due as of January 31st was $1153.67. The payment that Ms. Vogel paid on February 10th was for $1,091.50. So based off of that, she is paid through December because she would still have a balance due and owing for January. It's a small balance, but it still rolls over.
But it's
and so the
still-
last time she had a zero balance or better is in fact December.
Can I say something?
Yeah.
Because your guys' computer system doesn't show those things. So it doesn't give me a total of what was past due. So I couldn't actually do the math. All I could do was split that number. And then you guys charge $10 per money order. And I was unaware that it was $10 per. I thought it was $10 on top of my money orders. So that would be another issue there. There's no way to pay our rent without having a fee to pay. Whether we do it online or if we do it by money order, it doesn't matter. We have to pay the $10 fee. And each money order you have to do separate because it's $500 each money order. And then you have to add another $10. So there's, if you're paying a late fee, $1,500, you're paying another $30 on top of that for filing fees, I guess. I don't know, but $10 each portion instead of letting us do it online because they won't let us pay partial online.
I understand that, ma'am. All right. Right now, I think that the ultimate issue is to try to figure out how to get this balance down. Okay. So what I want you to do is try to contact Hawk, see if they can assist you. Because if Hawk can assist you and it's to the maximum amount, then you're just looking at trying to get $610 and some change and then you can get yourself back to ground zero. Okay.
Okay.
All right. So contact Hawk if you should have a tracking number, despite what DHS is telling you. You should have a tracking number for DHS. There's a form in your packet that you received called a rental assistance form.
I turned that
You'll
in.
need to, pardon?
I turned that into the court.
You already turned it in? Okay.
Yes.
I don't know if I have it. I do. In fact, I
Yeah.
have it. You're right.
I did.
Okay. So you've done that. And then what I'm going to do is adjourn this out to the 10th, 2026 at 3 p.m. That's an in-person hearing. You always, in the interim, can call the plaintiff's attorney, Ms. Dornbush, and see if you can work out some type of payment agreement or something on this, okay?
Yeah, and is there a number for the attorney?
Ms. Vogel, it's on the paperwork, but you and I have corresponded via email. So if you prefer to email,
a different attorney.
the paperwork says Matthew Pallets. That's the law firm I work for. It's a 248 number out of Troy.
Yeah, I see that
Yep,
on the paperwork.
That's my office. You can call me there, but as we've corresponded via email, you can email me as well.
Okay.
Thank you.
All right.
Thank
you. Is that it for Sile Farms?
It is indeed, Your Honor.
All right. Patty, have a wonderful weekend.
Thank you. You as well.
All right. Spice Tree Apartments versus Ashley Drummer. Drummer?
I'm here.
Okay. Hello.
Hello.
All right. What is plaintiff's claim in this case?
With costs, Your Honor, $4,403.27.
All right. Ms. Drummer, how are you intending on getting this paid?
I'm just gonna pay it. Right now, I am unemployed and I recently went through a divorce. So my husband was the primary breadwinner. So I cannot tell you how. I just know I'm going to get it paid.
All right. Let me ask you this. You just went through a divorce?
Mm-hmm.
Okay. Are there any issues? You don't have to give me any details. Are there any issues regarding child support or anything like that being paid, or?
It was being paid, but it hasn't been since January.
Okay, let's do this then. Here's what I'm going to do. I'm going to adjourn this out. Two things I want you to do. I'm going to adjourn this out to April 10th, 2026 at 3 p.m. Now that's an in-person hearing, Ms. Drummer, okay?
Okay.
I also want you to contact Hawk, okay?
Okay.
And see if they can provide some assistance to you.
Okay.
Okay.
I also
All right.
through
Go
DHS,
ahead.
but I also applied through DHS, but I heard you say that because I have two boys, 2 kids. So I heard you say that I think it's like $625 if they approve it.
Yeah, about $620.
Okay. So I was looking through the paperwork while I was sitting here, and I was already, as soon as this was over, gonna get in contact with Hawk. And yeah, okay, thank you.
Okay. All right. So there's that. DHS. I want you to also, there's a rental assistance form in the packet. Fill that out. Okay.
Okay.
We also have, and well, it doesn't matter where it was. We
It was in
also,
Washtenaw County. It was final
all right.
this January 2026.
All right. But you haven't received support since then.
No.
That's got to make it hard, right? Okay. We actually have somebody, a program that we have with the friend of the court. And they're wonderful people. And Spacer, would you be willing to speak with Miss Drummer?
Absolutely, Your Honor.
All right. So see, we're going to do that too for you, Miss Drummer. Okay.
Thank you. Thank you.
All right. So you're going to do Hawk. You're going to do that. We're going to put you into a breakout room with the friend of the court. See if we can get that going for you. All right.
Okay,
And
thank you.
try to take a little bit of the stress off, right?
Thank you so much.
You're more than welcome, Miss Drummer. We'll see you in a week. Okay.
Thank you.
All right. So hang on the line. We'll put you into a breakout room. Okay.
Okay. Have a good weekend.
You too. Thank you, Miss Mason. That's wonderful. Spice Tree versus, is it Manilo Haroon? I messed that up, I'm sure.
Hello, Your Honor. It's Manahil.
Say it again.
Manahil. There's an emphasis on
Oh,
the.
exactly how it is. I was trying to put things together in an, okay. All right. Never mind. My bad. All right. Good morning. All right. What is the claim in this case?
With cost, Your Honor, $2,893.18.
All right. And ma'am, how are you intending on getting that?
Yes, Your Honor. So I am a full-time student. So my main source of income is through my financial support from my school. And I had a financial hardship last month that put me behind on rent. But I am expecting funds that I have requested from the school by April 15th. So I intend to pay the full amount by April 17th, just to give some leeway for the funds to hit the account if that's possible.
Okay. What school are you in?
I'm at University of Michigan.
Oh, I'm sorry to hear that. No, I'm kidding.
Did my undergrad at OSU, so I hear that a lot.
Oh, Ohio State? Really?
Yes.
See, then I have two reasons not to like you. I'm a Maryland grad, so
Oh,
none
wow.
of this is working for you. Okay.
Oh no.
All right.
I take it
The
back.
only thing that could have been worse is if you were a Spartan. Then I wouldn't even talk to you. All right. So okay. So let's do this. Are you going to have some type of verification of those funds coming in or something like that, or something you can?
Yes. I have email conversation with my facilitator for the funding grant that I can provide.
Okay.
I just haven't the rolling doesn't start till April 15th. So that's why I was just waiting for them to get in contact with me. But I can provide that documentation. I also do work a part-time research job, so I can and this based on hourly need. And I've talked to my supervisor since, and they have stated that I will be receiving more hours. I have an increase in my pay stub to prove.
Okay.
Yeah.
Gotcha. Okay. Here's what I'm going to do. I'm going to adjourn this out 1 week to the 10th at 3 p.m. Okay. That's an in-person hearing. In the interim, what I want you to do is contact Ms. Dornbush and provide her what documentation you can, see if something can be worked out regarding this, to give you the time frame to get everything paid. Okay.
Sounds good. Yes, I can definitely do that.
Fair enough. Okay. And I really don't dislike Michigan at all. I grew up in Ann Arbor. I just say that because it makes me feel. All right.
That's good to know.
Okay.
I definitely miss Ohio, but that's my memory.
All right. You have a great weekend.
Thank you. You too.
All
I
right.
do have a quick question, if that's
Yes, ma'am.
should I contact the attorney office, like phone number, to get an email, or would this need to be like in person?
Well, Ms. Dornbush.
Oh, I'm so sorry, Your Honor. I thought when I heard about the in-person, I thought she was asking about the court hearing. You can contact me at the phone number that is on the paperwork. It's a 248 number out of Troy. And I can also put in my email address in the chat if you'd like to correspond via email. That is just fine.
That would be really helpful.
Okay.
Thank you.
You're welcome.
Appreciate it.
Have a great weekend.
Thank you.
Next case is in the State of Kansas versus Carrie Cates. Case number 25 TR 2628. Counsel state their appearances, please.
Jerry Regier on behalf of the state.
Your Honor, Darren Patterson appear on behalf of Carrie Cates. Miss Cates does appear personally from the Butler County Jail. And Mr. Regier, is what is requested acceptable?
Your Honor, the state is prepared to proceed in this matter.
Your Honor, based upon that, I would announce this time, Ms. Cates will be entering a plea of guilty to count 3, no proof of insurance. States agreed to dismiss counts 1 and 2. At the time of sentencing, the agreed recommendation is a $300 fine. Court costs, 120-day controlling sentence, and a 6-month non-reporting probation.
Mr. Regier, is that your understanding of the agreement?
It is, Your Honor, and although not specifically discussed during the context of plea negotiations, the state does not take a position on the awarding of jail time credit if the court determines that is appropriate in this matter. State's information is there was previously a first appearance in this matter approximately 1 week prior before District Judge Satterfield, at which time the defendant appeared in the same fashion that she does today.
Very well. And counsel, this was a guilty plea, is that correct?
Correct, Your Honor.
All right. Ms. Cates, have you heard what the attorneys have told me?
Yes.
And is it correct your intention today is to enter a plea of guilty to count number 3, no proof of liability insurance?
Yes.
Do you understand while there's recommendations from the attorneys, the court is not bound to follow those?
Yes.
The maximum punishment available to the court on a B misdemeanor is up to 6 months in the county jail and a fine not to exceed $1,000. I'm not saying that's what the sentence will be, but those are the maximums. I go over that while there's recommendations of the attorneys, the court isn't required to follow those, just so you know. All right.
Okay.
You understand that with a plea of guilty, you'd be waiving your right to a trial.
Yes.
And and has anybody forced or coerced you in some fashion to enter this plea?
No.
Are you under the influence of any medications or intoxicants at this time?
No.
Okay, ma'am, on or about November the 20th to 25, and while you were in Butler County, Kansas, were you operating a motor vehicle on a public roadway or highway without proof of liability insurance?
Yes.
Very well. I do find the plea is knowingly and voluntarily entered with the advice of good counsel, that there is a factual basis for the plea, and find the defendant guilty of count 3. As charged, counts 1 and 2 are dismissed with prejudice pursuant to the agreement. And counsel, is there any additional statements the parties wish to make before I pronounce sentence? Mr. Regier?
Nothing further from the state, Your Honor.
Mr. Patterson?
Your Honor, just briefly, I would tell a court that her booking date was March 26, and she's been in jail ever since on this case. She does reside in Wichita and would ask the court to allow her to have probation in order to help take care of her kids. She has 5 kids that she has to take care of, so that she is asking the court to allow her to be on probation so she can resume those responsibilities.
Ms. Cates, is there any statement that you'd like to make before I pronounce sentence?
I just wanted to say I was on the first missed call, or the first missed appearance that I had. I was on the call, but during the call, my ex, who is now in rehab for drugs, I apologized, strangled me. And the Wichita Police Department came and got me and took me to Wesley. And there is a case on that. But so the kids don't have a parent right now. They're with an aunt. So I would really like to be able to be there for my children.
Right. Are there any other cases that you've got or you've been ordered to serve?
No.
Do you have a jail sentence on something else in Sedgwick County or anything like that?
No.
Very well. I will impose the 120-day jail sentence that has been recommended. I will give the defendant credit for time served on this matter, which apparently is March 26th of 26. I will impose a $300 fine, which is the mandatory minimum, court cost of $108, and attorney's fees of $200. Ms. Cates, how long do you think it'll be before you'll be able to get those taken care of? If my addition is right, and it isn't always, it'd be $608.
Can I make a payment plan?
Well, yes, if that's why I'm asking how long you think it'll take to get it all taken care of.
If I could set that for right now at $50 a month and then hopefully make it sooner, or should I do more? I'm just trying to take care of 5 kids by myself at the moment.
Well, I understand that, and I want to be realistic on here. Okay. I'm going to, well, those costs are assessed. I'm going to make this a 12-month non-reporting probation because I think she's going to need more time, particularly if she's doing it $50 a month to get this taken care of. So I'm going to set that at 12 months non-reporting.
I appreciate that.
No, I'm not done yet, Ms. Cates. I'm going to order that you make a mandatory minimum of $50 a month. And actually, you're probably going to need to make more than that to get this taken care of. Okay. Now, once you have paid all of this, if you've served at least 6 months of your non-reporting probation and this is paid off, then I would consider closing your probation early.
Okay.
The thing that you don't want to do is just stop and not make the payments, because ultimately then what generally happens is there's a motion to revoke your probation for failure to comply.
Okay.
Because this is a condition of the probation. Another condition is no law violations.
Okay.
So if it becomes an issue for you, you might want to reach out to Mr. Patterson and see what can be done, but you're going to be better off if you can get this taken care of, and the sooner the better, because there a lot of times people they don't get these things taken care of, and their license gets suspended, and it kind of goes into a spiral where they just keep getting in trouble.
I will make it happen.
All right. I
Honor.
will. Yes.
Was that a $200 attorney fee or a $250?
I'm sorry, I ordered 200.
Okay, thank
Is
you.
250 the typical one?
Yes.
I've already ordered 200, so I'm going to keep it there, but thank you for correcting me on that. All right. Well, my lack of memory saved you $50 there, Ms. Cates.
I appreciate that.
It wasn't intentional. It just, like I said, my memory lapsed. So, all right. So, you have any, and you need to contact the clerk of the district court, find out how to make those payments. There's different ways you can do that, and they can explain that to you. But you need to be making your mandatory minimum of $50 a month, and you're by the last business day of a month. So looks like April 30th, before, I'm not sure, probably 4:30. They may close at 4:30 or 5, but
Okay.
But the last business day that the courthouse is open. So if it falls on a Saturday or Sunday, you need to do it before then. Okay.
Okay, thank you.
Any other questions?
Not from me.
Very well. Counsel, anything further?
Not from the state, Your Honor.
Nothing further.
Very well. This matter is adjourned. She can be processed out at the Butler County Jail, and we are adjourned. Ms. Cates, good luck to you.
Thank you so much.
All right. Next matter is State of Kansas versus Matthew Stephen Crawford, case number 24 TR 2296. Council state their appearances, please.
Jay Regier on behalf of the state.
Your Honor, Darren Patterson here on behalf of Matthew Crawford. Mr. Crawford does appear personally from the Butler County Detention Facility and is just now sitting down, Judge.
All right.
Judge, this is a warrant to show cause. I would tell the court there is one alleged violation. That alleged violation is that he was ordered to do 5 days jail as a condition of a 1-year non-reporting probation. Is because this was a driving while suspended second, which had a mandatory 5 days. Mr. Crawford does stipulate that he has, or he did fail to serve that 5 days as previously ordered.
All right. Mr. Crawford, is that correct?
Yes, it is.
You understand that you do have a right to a hearing on whether you violated the terms of your probation, and with this admission, you'd be waiving your right to that hearing?
Yes, Your Honor.
And that if that hearing were to be held, the burden would be on the state to show by a preponderance of the evidence, which is more likely than not. Have you had sufficient time to go over this with Mr. Patterson?
I believe I have, yes.
Right. Did anybody force or coerce you to make this decision to this admission for today?
No, Your Honor.
Are you under the influence of any intoxicants or medication that's at this time?
No, sir.
Very well. I will find that the admission is knowingly and voluntarily entered with the advice of good counsel, and find that based upon that admission that the defendant did violate the terms of probation as ordered by looks like Judge Webster. So I will revoke his probation at this time. Counsel, was there any additional arguments that you wish to make?
Your Honor, if the state may be heard very briefly.
Yes.
Your Honor, pursuant to the request for revocation in this matter, it does appear to allege that the defendant failed to serve the 5 days in the Butler County Detention Facility. The state does not have an objection to the defendant being ordered to serve those 5 days and then return to non-reporting probation as previously ordered in the current case. The state does not object that the defendant received credit for time served. However, the state's information is that there is still 1 day outstanding on that 5-day sanction.
Okay, had this been discussed as a condition or an agreed condition of the plea, of the admission? I said that poorly. Was this a plea negotiation that was communicated to the defendant in advance?
Judge, I can tell the court I did make some requests to Mr. Regier, but there has not been a meeting of the minds, if that's what the court was.
Okay. I just needed to know if I needed to review that with the defendant, that the court's not bound to, if there was a recommendation of the parties, of the attorneys. Okay. Thank you, Mr. Regier. Anything further?
Not from the state, Your Honor.
Mr. Patterson?
And Judge, I believe there is additional credit for time. I've reviewed the records that we have available to us through Vine, and it does show that he was arrested on this March 24, 2026 in Sedgwick County. That Sedgwick County detention does show he was transferred to Butler County on March 30, 2026. And then the return on the bench warrant bond forfeiture does show, that's filed in this case that the court has, shows the arrest March 30, which would coincide with his transfer from Sedgwick County to Butler County, where they then executed this bond forfeiture bench warrant. Now, Judge, this is where it gets a little, I guess, I don't know if he's sitting in jail correctly on a warrant that's correct or not. And I'm going to point this out to the court. On file stamp March 30, 2026, in the court file is a bench warrant bond forfeiture, which is the return. And that's where I find the March 30 arrest date. But if you read that, it states that that bond forfeiture bench warrant was failing to appear on February 11, 2026. I would also found in the court file stamp December 1, 2025, that the February 11, 2026 hearing was canceled and no new date was set. So I'm not sure how he can have a bond forfeiture bench warrant for a date that was canceled and not a new date set. Now, I'm not saying this is an excuse for his original violation, Judge. But he is in jail on this case, obviously. And my count is he's got 10 days in now, not just 5, based upon.
You're talking from the 24th then?
Yes, yeah, where he was in Sedgwick County, with credit time. He was in there for this. He got arrested and then transferred over. So Judge, I believe he's done double what Judge Webster originally ordered. Now it has 10 days that he served. That's basically on his own. He made that happen rather than just do 5. He's now done 10. So we would ask the court to accept that as the punishment in this case for this violation, the one violation there is, and either close it or resume a non-reporting probation for 1 year.
And Your Honor, if the state may have the opportunity to respond very briefly.
Very briefly.
Yes, Your Honor. As the court has already observed, pursuant to the sentencing journal entry, this is defendant who is convicted of 1 count of driving while suspended, a Class A misdemeanor, with the which does require a mandatory 5 days in jail upon a second or subsequent offense. The state's information is that the original occurrence date in this matter was July 6, 2024. After the May 23rd, 2024 legislative fix to KSA 216615 occurred, pursuant to subsection A to B of the same, quote, when computing the defendant's sentence, the following shall not be considered: time spent incarcerated pending disposition of the defense case, any time spent incarcerated in another jurisdiction, if no hold has been issued in such jurisdiction for the case being sentenced. Therefore, it is the state's information that and position that the defendant still has 1 day outstanding on the 5 days as required by law.
All right. So was he in custody on something else? Is that what you're saying?
Your Honor, I cannot advise the court as to whether or not he was. There were any other pending matters, but it does say that the time should not be considered if there are no other holds issued in the other jurisdiction, based off the state's reading of the statute.
Judge.
Yes.
This court did have a hold on him. It was this bond forfeiture bench warrant that was filed February 13, which would cover the time he was in Sedgwick County, which was March 24.
All right. I'm going to be giving him jail credit for March 24th. Judge Webster had issued a bench warrant. If not the majority, it's very common that individuals get picked up in a different county and arrangements have to be made for them to be forwarded on to the county where the warrant's from. It's my belief, if that's the only thing they're being held on, they should be getting jail credit for that. So I'm going to give him credit for that. That being said, well, Mr. Crawford, is there any statements that you'd like to make before I announce my decision?
Respectfully, sir, I do apologize for this whole issue coming to this, what it has. I do have a 5-month-old and 6 other children that are depending on me out there. My wife has had to put the 5-month-old in daycare since this has happened, and I really have a business that's suffering from all this. So I would respectfully like to make that known.
Well, have you paid you were supposed to have 30 days to pay the $208. Did you pay any of that?
I can do that today if I can get my, but no, I didn't.
Did you pay any of it before?
I don't remember. I don't think I did. It's been a while, but I can pay that today.
Well, why did you not show up as you were ordered to do so? It sounds like Judge Webster gave you a break and, allowed you time out so then you could report in.
Yeah,
Generally, those are made arrangements so that to accommodate people's employment or family, that sort of thing.
yeah. My wife was having a miscarriage the first time, and she was anemic and she was hemorrhaging. And then the second time around, my daughter, my 5-month-old, she was a couple months old, was really sick. And like I said, I watch her during the day and run my business, so it's my responsibility to take care of the baby. So it's there's a lot on my plate, Your Honor.
So your solution was just to blow it off?
No, I called. I actually called and told them I was not going to be able to make it, but that didn't suffice, obviously. But I did make a phone call. I did try and contact the court.
Well, a phone call doesn't cut it, sir.
I know.
Mr. Crawford, when you're ordered to report to jail and you fail to do it, you violated the terms of your probation. Judge gave you an 8-month sentence, and that's what could be imposed today for you just to serve. Now, I don't see this as just, whoops, another go round. You had a direct order to show up at the jail, and a phone call just doesn't cut it. I'm going to order that you serve until April 17th. You can be processed out on that date after 9 a.m. before 5 p.m. so they can process you out, but you'll serve until then. Then the remainder of your case will be non-reporting probation, as you didn't pay anything on your court costs and fees and you're past due on that. I'm going to order that the $208 go to collections. Mr. Crawford, I reviewed your file, and you use your family as it appears to, every violation that you got, you keep using your family. Counsel, anything further today?
Your Honor, what is the court's order, if any, in terms of any jail time credit in this matter?
As I indicated, I'm giving him credit since 3/24 of 26. I haven't calculated the time. If he had earlier jail credit that was given at the time of sentencing, that needs to be calculated in. I have not modified the sentence of 8 months. He will serve much less than the 8 months, even with the additional 2 weeks that I'm putting on from today. So he'll have credit from 3/24 until April 17.
Very good, Your Honor.
Plus whatever, if he had any other in advance of that or earlier than that time. So.
Nothing further, Judge.
Very well. This matter is adjourned and the defendant can be taken back to his cell. Next matter is State versus Jennifer Nicole Hart. Counsel state their appearances, please.
Chair Regier on behalf of the state.
Your Honor, Darren Patterson appearing on behalf of Jennifer Hart. Ms. Hart does appear from Courthouse Security 3 video station. Judge, this is a warrant to show cause. I have went over the allegations of the warrant to show cause with Ms. Hart. I would tell the court she is going to waive hearing. She is going to stipulate that she did violate the terms of her probation.
All right. Is that pursuant to the motion to the stated reasons in the motion?
Yes, Your Honor.
Okay. Is there any other agreements or recommendations that have been negotiated?
No, Your Honor.
Not from the state's perspective, Your Honor.
All right. Ms. Hart, have you heard what the attorneys have told me?
Yes.
Okay. Is that correct? Well, do you understand that you have a right to a hearing on whether or not you violated the terms of your probation?
Yes, I do.
Do you understand that the state would have the burden of showing by preponderance of the evidence your violations? And you would have the right to have counsel and have him cross-examine state's witnesses and so forth?
Yes. Yes, Your Honor.
And is it correct that you wish to waive your right to that hearing and hear that evidence and admit the violations as alleged in the warrant to show cause?
Yes, Your Honor.
Have you had sufficient time to discuss this with Mr. Patterson for making this decision?
Yes.
Has anybody forced or coerced you in some fashion to make this decision?
No.
And are you under the influence of any medications or intoxicants at this time?
No, Your Honor.
Very well. I find the admission is voluntary. The waiver of a hearing is voluntary with advice of good counsel. I find that she has violated the terms as stated in the warrant to show cause. And I will hear recommendations as to consequences at this time, beginning with the state.
And Judge, I'm sorry to interrupt. Prior to hearing from counsel, Your Honor, there was emails sent out to counsel and court on this case. One of them from Ms. Taronis, where she passed on a letter from a treatment provider, and then I added to that two additional documents for disposition also.
All right. I have not reviewed those at this time. I saw some emails coming in. And I see that, yeah, that because Ms. Taronis came in at 1:30 and yours at 1:34. So I'll take a moment to look at those. All right, counsel, there's 3 documents, it appears, that were submitted. One from a T.J. Miller to, I believe that was for a treatment summary dated March 31st. There was a Gmail that looks also from Mr. Miller with a March 26. And the letter addressed to me, I don't see a date, but that was also from Counselor Miller at Holland Pathways. I have gone over those very quickly. So if counsel want to address those in their comments, I would appreciate it. I do want to take a moment just to look a little bit further at the violations and timing thereof. Very well. Before I hear from counsel, Ms. Drones, is there any recommendations that you have for the court on this matter?
Yes, Your Honor, at the time that I requested this warrant, I would have asked for outright revocation due to the lack of progress and continued drug use. But after speaking with the counselor and her progress since the warrant was filed with Holland Pathways, I would like to see her complete inpatient treatment and see if we can get her back on the right path and stay on that path.
When is her inpatient treatment supposed to end?
I don't have an exact date. I know she is about 3 to 4 weeks in, and they're wanting to keep her for approximately 60 days.
It's May 7th.
Okay, well, she's here at court security today. So was she brought by some of these inpatient treatments are not the way that they used to be, where the person stayed there all the time. Can anybody tell me how this Holland Pathways operates? If the clients are going out during the day and then returning at night, or if they're there all the time, whichever?
I do have my case manager here with me, but we get to go off site to one meeting at night if we're not on the behavior list or whatever. And I get to go out. So it's for an hour. Is it an hour? an hour every night, but we are in classes from 9 a.m. to 11 a.m. and then we go back from 1 to 4. And then we do gratitude at 6 and then another meeting at 7. So then that's how our night ends.
So other than that hour a day, you're there at the facility.
Correct.
Okay. All right. Counsel, any additional statements, Mr. Regier?
Your Honor, on the issue of disposition, the state is recommending that the defendant be ordered to serve a sanction at a time to be determined by the court to be appropriate. The state's position is that no, although the CSO has referred to a number of new developments, the state does consider the violations as alleged in the request for revocation as originally filed to be quite significant, although the state is prepared to recommend that the defendant be ordered to serve a sanction at a time determined to be appropriate by the court. While the state does not oppose the defendant receiving credit for time served, the state's position is that should not be counted towards any prospective sanction the court may order. It would appear that in the original sentencing journal entry, the court did order that the defendant shall successfully complete a drug and alcohol evaluation at the CSO's discretion and follow recommendations. The state would be recommending that the defendant be ordered to complete a new one, although the state cannot say for certain whether or not a drug and alcohol evaluation has ever been successfully completed in this case. Insofar as probation is concerned, if the court does determined that the defendant returning to reporting probation is appropriate, the state would be recommending an extension of reporting probation of at least 12 months. It would appear that the defendant was initially sentenced in this matter in July of 2025, and we appear to be fast approaching the conclusion of that 1 year as originally ordered.
Thank you, Mr. Patterson.
Thank you, Judge. Judge, this is a case that started out as a driving while suspended second. Although there was the order to get a drug and alcohol evaluation, I don't think it was necessarily a drug case, but I think when she got on probation, it became quite clear very quickly that she has and has an addiction issue with some serious drugs. The assessment, I think we have one, the March 31 email from Counselor TJ Miller that the court has kind of goes through a treatment summary where they did do an initial intake drug screen when she entered the program, which she was positive for some very serious drugs. So you can very clearly see she has a serious addiction issue that needs to be treated. Otherwise, she'll never be successful on probation or anything else she does probably in her life. She has a great start at treatment, as has been stated, and I note that the one letter that doesn't have a date that's addressed to the court, the Counselor TJ Miller does state, based on current clinical presentation progress, I respectfully recommend that Jennifer be allowed to continue with the treatment as planned. Continuing and treatment, I think, is a very important thing. She did have a sanction. We'd asked court to count as a sanction. When I reviewed the Vine records, it does show this is a warrant she was picked up on in Sedgwick County. This was a very quick transfer, though. She was arrested or booked into Sedgwick County February 11, transferred to Butler County, and then she bonded out on February 13 from Butler County. So approximately 48 hours she was in custody. So we'd ask court to consider that as a sanction, which this court has no obligation to follow the rules on those felony cases, where a lot of times for drug cases, they have a 48-hour sanction as their first quick dip. But this seems to be that kind of case almost. But so she's had a sanction. We would just ask the court that she be allowed to return to treatment. Apparently she has a driver there with her that brought her who would drive her back. And that's probably the best case scenario for her, Judge. So that would be our request this time, and the court order that she have an extension of probation, and that this be a new order that she comply with the recommendations of Holland Pathway for treatment and aftercare. Thank you, Judge.
All right. Ms. Hart, is there anything that you'd like to tell me? And before you get too deep into whatever you're going to tell me, I would like you to repeat when it is that you're scheduled to complete your inpatient treatment program.
I think TJ said it was May 7th is my exit day from Holland Pathways, but I plan on trying to, if insurance allows me, to get into reintegration at another treatment facility for an extended 30 days before I go to sober living, just to have a higher chance of, or a less chance of relapse, higher chance of, successful sobriety.
All right. Are you under any other court orders in regards to probation or
No.
anything like that? This is your only case?
Yeah.
Well, I find that she has violated the terms of her probation. I'm going to continue the matter until May 15th at 1:30. And counsel, if she is still in Holland Pathways or has been accepted into another inpatient treatment, I would consider a continuance. So those should be treated, that you're, I'm going to consider how you've done in the treatment, Ms. Hart. Some people are very open and very good about wanting to get the treatment. But I found out I can't always just spot that. I've seen an awful lot of people that they don't go to treatment until they're about to go to jail. And then that's what they do. There's a lot of positive things that are mentioned here for you on your behalf. But I want you to successfully complete that. I would like that to if you have been released from that treatment, you're still on probation right now. So you need to report to Ms. Torrance, and keep in contact with her until you come back to court on May 15th at 1:30. And if counsel have any additional information concerning, and if there's any updates from the Holland Pathways, then I would like to have that. Ms. Hart, let me just make it real plain to you. If you check yourself out against their orders, you're going to make my decision very easy.
Okay.
Easy for me would be difficult for you. So I wish you luck in your treatment and follow through with it. I deal with this sort of thing in my care and treatment cases. And I was a prosecutor and defense attorney for many years before I took the bench. A lot of those dealing with drug cases. I've seen more overdose to death in the last 6 years dealing with that docket than all the 30 plus years before then. It's just devastating what these things can do, that fentanyl. So I wish you the best, but we'll continue this to May 15th at 1:30.
Thank you.
And Your Honor,
Yes,
is it the continuing orders of the court that the bench should continue a bond as well as appear in person at the next setting?
yes.
Thank you, Your Honor.
Mr. Patterson, anything further?
Nothing further.
Okay. Good luck to you, Ms. Hart.
Thank
See
you.
On the 15th. All right.
Good morning, everyone. I'm Judge Sylvia Holmes. Thank you for being present present. Mr. Mathis, can you still hear me all right? Mr. Blackburn, can you hear me okay? You're on mute, sir.
Good morning, Judge. I can hear you just fine. Thank you.
Fantastic. Mr. Betts, can you hear me all right? You're on mute, sir. Mr. Betts, if you're trying to respond, you're on mute. You're going to need to
Yes,
unmute.
Judge, I can hear you fine.
All right, fantastic. Good morning, everyone. We are here for cause CR 24003880, State of Texas versus Daniel William Betts. On behalf of State of Texas, Travis County, Mr. Mathis.
Yes, Judge.
Good morning, sir. And on behalf of Mr. Betts, Mr. Blackburn, counsel.
Morning, Judge.
Good morning to you both. All right, Mr. Betts, thank you for being here as well. All right, we've got 3 pretrial matters. So we've got a motion for discovery, a motion to suppress, and a motion to dismiss. All right, let's handle motion for discovery. What's still needed, Mr. Blackburn?
I know that we file a standard discovery request in every case, and my partner, I know that I think Mr. Mathis or the state has shared with us any matters or any evidence that they have. And so I'd just like confirmation. And so I know that we file a request, and I'm sorry, I think I may have to video mute you to pull up the motion, or I may be able to have my paralegal help me. Can you pull up and show me the motion that the judge is talking about, the motion for discovery? Is that styled, Judge? Is a motion where I'm asking for you to rule on it?
Yeah, it was a request for discovery. So here's what we've got, y'all. Because I'm ready for jury trial for this. Here's the roll. So case was filed September 19th, 24. Letter of rep came in almost immediately, and implied letter rep, y'all sent it in on the 16th of October. First pretrial was January 28th, 25. Someone came. I don't know if that was Mr. Betts on your own or Mr. Blackburn, you. And then offer was made from prosecution. Defendant wanted to review it, came back March 4th, 25 for a second pretrial. We got a discovery request that got filed on the 10th. So after you filed your letter of rep, standard notion for discovery came in. I'm assuming that some of that took place at that first meeting in the 28th of January. And there was one on March 4th of 25, another one on May 6th of 25. And then the jury trial setting January 23rd of this year. Mr. Betts, you appeared for that, but I remember it was defendant's continuance. I think you had you're doing something really fun at that time. So I don't know how that went, but that's the reason for it. And so now we are here. So motion for discovery. Mr. Mathis, have the probable cause report, police officer's affidavit, and the video been provided to the defendant?
Yes, Your Honor. So there's yes, Your Honor. So we have the citation uploaded, the trooper's body camera and the trooper's dash camera have been uploaded and released to defense.
And then, okay, and Mr. Mathis, I was going to ask, we have counsel here. So because counsel's here, they can get their own copies of those things.
Okay.
All right. Well, we got that.
So Judge, and sorry to interrupt, but just to answer your question, I didn't think that it was a motion that the defense was asking the court to make a ruling on. And then just do I understand correctly, this is not a court of record, it's not a court reporter taking this down, is that right?
That's absolutely right. So for anyone here, you want to appeal, it's completely de novo. You just start the whole thing over.
And so what I was asking more was the police officers, they calibrate a radar gun, and that sometimes radar guns or instruments or devices, machines, whatever they call them, sometimes they're not perfect. And there's logs that they keep to show that these things are maintained correctly or that they're not maintained correctly.
We are all contemporaries in the defense world. I got it. What is that you want from prosecution that you can use?
Yeah, and if they're not maintained correctly, I think that's Brady, and I think the state needs to pass that over. So if
you want the logs for the radar gun.
Yeah.
Okay, cool. Logs for the radar gun, Mr. Mathis, provide that.
Understood, Your Honor. We don't have those at this time, but we will go about acquiring those.
Can do. These are all, there's not a whole lot that's going to come out of a speeding ticket, right? That's why I'm kind of covering the basic things here. So the logs for the gun, okay. Was it radar, Mr. Blackburn, or was it a LiDAR?
Additionally, I think it was a radar, Judge. And additionally, I think that and whenever I have these trials on these cases, the officer talks about how he calibrates it beforehand. And I think that they before their shift, they calibrate it to make sure that it's working correctly, and they take a video of that. So we also want the video. I don't think we have the video of the pre-shift calibration. We also want that.
If it exists,
and
Mr. Mathis, turn it over. I don't know if they
Understood.
do that, Mr. Blackburn. I don't know. If they've got it, certainly it can come in. I don't see any reason why not. I know that they do. I've heard that testimony being done a lot. I don't know that they always record that. Sometimes they do. I know they typically do. Again, this is, just sort of commonly what I hear is when they do the stop, they take a picture right then and there to kind of show the matchup. And I don't know if they do with the log. But either way, Mr. Mathis, take a look. If officer has any of that, I'd come over. All right. Anything else, Mr. Blackburn?
Yeah, and then sometimes they sell those the companies that make the devices, when they sell them to the law enforcement agency, it comes with an instruction manual or an owner's manual or an operator's manual. And sometimes those operators manuals have statements in there that say something like, this is not warranted for any special perfect purpose, or it's not guaranteed to work or something. I think that counts as Brady evidence. And so we'd like the state to produce that in addition to any other Brady evidence. I'm not sure if there was a discovery, if there was a disclosure about any. I'm sorry,
I
Judge.
want to rule on the first one. Let me respond. So the instruction manual, what are the odds that the officer has that? I'm thinking about in terms of being able to find that and produce it.
So yeah,
Is that
it's
something
often not the officer who like installs it, but the law enforcement agency, and they're an arm of the state. So whether it's the guy down at the maintenance shop, or if it's something that they keep just in a matter of course, down at the police officer at the law enforcement agency's
All right.
headquarters.
If you got an instruction booklet for the radar, turn that over to Mr. Mathis.
Yes, Your Honor. Again, we don't we currently don't have that, but if it exists, yeah.
If it doesn't exist, it doesn't exist. I'm just saying if you've got it, you can find it and it can be turned over. Right. Cool.
Understood, Your Honor.
If it exists. What else, Mr. Blackburn?
Okay. And then as far as discovery goes, then the last thing I think I was asking for was if there's any disclosure material, I think is what the county attorney's office calls it. But if the officer's been reprimanded for being a bad cop or not following the rules, if there's any internal affairs investigations, anything that might be discoverable as Brady, bad conduct of the officer, that type of stuff.
Any information that might go to impeaching the witness, Mr. Mathis, if you have knowledge, turn that over. All right, that sounds good. What else, Mr. Blackburn?
I think that as far as like unprovided discovery, that would be all that I would be asking the court to order them to turn over at this point.
All right, we do that. How about the motion to suppress?
So the motion to suppress, Judge, that's a boilerplate motion that I file in every single case.
Totally got it.
Sometimes we have things that come up that are constitutional issues that can be raised at any time, maybe after a jury's sworn. And so when I get the rest of the discovery from the state, there may be additional modifications that I made.
All right, yeah. Right now, there's nothing to suppress, but certainly if you find things that come up, you can always raise the issue again. Totally understandable. All right. And then motion to dismiss lack of speedy trial.
On this, Judge, I think when you were kind of going through before the different setting history as far as, when motions were filed or whatnot, I have, this I think is what we call the register of actions. And is that what you were reading from when you were?
Yeah, when you look at that, that's emails and conversations. So the functional part of that I see are that the first pretrial was January 28th, and our notes say offer was made. Defense wanted to review it, completely valid. March 4th was the second pretrial. May 6th was the third pretrial, and then we didn't do anything without a jury setting, which was the 23rd. And then Mr. Blackburn, you weren't here for that. Mr. Betts came though. He needed continuance. He was making an appearance for another event he was doing that afternoon. Needed to travel to it, so we granted that continuance. But we're ready for jury trial. We'll give you April 24th. And I'd say,
Yeah,
Mr. Mathis?
so on my motion to dismiss for denial of speedy trial right, Judge, I think that as it may be laid out in the motion, but for whatever reason, when we made the setting, so I think there was a setting where there was the pretrial hearing, and then when the offer was made, they said they would dismiss it with the deferral and the driver safety course, which I think my client maybe did that driver safety course already. But with the complaint and affidavit being filed, then we were notified. I think we were told at the court date, you're going to receive notice of this next setting, and then it went some like 8 months or something with the case not having a setting and not being put on the docket. And we're urging in that motion that delay has prejudiced my client and has violated his right to a speedy trial. And based on the analysis in the U.S. Supreme Court case of Barker versus Wingo, one of the factors, of the four factors that the court is to consider is the length of the delay and then also the reason for the delay. So I don't know what the state's answer is for, why, they would go that long without addressing this matter or, bringing it up. But, why we go 8 months without it being on a docket when we had been making appearances, had been, requesting to resolve this case and wanted to get this case resolved. And so based on the analysis that the Supreme Court lays out also in Oren v. State and that Texas appeals court case out of Fort Worth, 254 Southwest 3D 560, the reason for the delay weighs heavily against the state, and delays caused by court congestion or administrative oversight or doctive management are attributable to the state, as is held in the Zamorano v. State case, and that's a court of criminal appeals case out of 2002, 84 Southwest 3D 643, and then also Drago v. State, 96 Southwest 3D 308, also a court of criminal appeals case. And when the case is allowed to languish off the docket through no intentional error or no cause of the defendant, that those delays are to be attributed against and to be held against the state and not the defendant. And based on the defense asserting a speedy trial right and not acquiesce to the delay, we believe that the court should find that delay is unreasonable, should be taxed against the state, and that the defense shouldn't be prejudiced further by being denied our right to a speedy trial. And based on those factors, the length of the delay, the cause of the delay, and it being attributed to the state, we ask the court to grant this motion to dismiss for denial of my client's right under the Constitution of the United States and the Constitution of the state of Texas for his right to a speedy trial.
Mr. Mathis, how would the state respond?
So, Your Honor, with regards to this 8-month delay that occurred between, I believe, March of 25 and January of 26.
May.
May,
last
my
trial was
apologies.
May 6th.
May 6th. My apologies, Your Honor. So with regards to that, state has had an offer on file for the defense during this period of time. It hasn't been the state requesting any of these resets. And additionally, the 2 resets that have occurred on this case have been requested by the defense. Additionally, even if that 8-month delay is to be presumed due to the fault of the state, an 8-month delay on a Class C misdemeanor, while obviously we'd like to move these faster, is not something outside the bounds of sort of what the timeline often looks like for these sorts of cases. And when that's taken up with the fact, and when that's weighed against the fact that the continuances that we do have noted in this case were requested by the defense, believe that the defendant's speedy trial rights haven't been violated and the motion should be denied.
Anything further, Mr. Blackburn?
Yeah, in response to that, I think that that what Mr. Mathis is arguing, I would argue the opposite. He says this is a typical amount of delay for these type of cases in a minor misdemeanor Class C case, and I think it's the opposite. If we're talking about a multiple homicide with a death penalty, and we're going to need multiple experts, and that there's DNA evidence and tons of discovery that's going to have to go through, it's more understandable, and the court records in the cases on these issues hold that is a reasonable reason for a case to take longer to go to trial. But on a speeding ticket case, that a smaller case should be brought to trial sooner. And even though Mr. Mathis may not have personally requested a continuance, as I said in the Supreme Court cases, that those delays, whether they're administrative or perfunctional, just those type of delays are not to be held against the defense, they're to be held against the state. And I believe, Mr. Betts, were you wanting to offer testimony about the harm that you have suffered?
Sure. I mean, in the intervening time, I picked up a new traffic ticket, which complicates it. And had the issue been resolved prior to that,
so your attorney could represent you on both tickets?
I'm sorry,
no,
Judge, I couldn't hear that. Could you?
I understand that,
sorry.
Mr. Betts, you picked up an additional criminal charge in our court after this case was filed that may have constituted an additional delay?
No, Judge, that didn't cause any additional delay. In fact, I think that charge is what brought this charge back on the docket. It wasn't on the docket. It had fallen completely off. And it was by virtue of that it was brought back. And my ability to resolve this subsequent charge is hampered by the remaining pendency of what we assumed at that point, when it had fallen so far off. We thought, that this speedy trial issue would be salient at the very best, and that frankly that we thought that it was gone. That oftentimes happens with tickets or can. I've certainly seen it in the past. So that was what I would say is my immediate harm.
Pre-trials. Mr. Blackburn, I'd like to refer to you and not to your client directly. I'm going to deny the motion to dismiss for lack of speedy trial. And here's why, y'all. Mr. Blackburn, I recognize that you don't practice in justice court a lot, but I do not find this to be an unreasonable delay for traffic tickets. It is incredibly common for people to delay as long as possible with these. Often, for what Mr. Betts just highlighted, they're hoping it will just sort of fall off, but it did not fall off. I have cases still pending from 2021, and they are still actively being pursued. Sometimes it's because the defendant has disappeared. That is not the case here, and we're happy we have two licensed attorneys. Mr. Betts is an attorney, Mr. Blackburn is an attorney. In fact, you are law partners, correct?
Yes, ma'am.
Fantastic. I know you know what you're doing because you are good felony trial attorneys, right? So justice court's a whole lot different, but y'all, not unreasonable. We gave you a jury trial in January. Mr. Betts, you couldn't make it. Y'all delayed it, right? I'm happy to give you a new one. Here's 2 dates I can give you. So y'all let me know, Mr. Blackburn. The fastest I can get you to court would be April 24th, but I've given you your motion for discovery, which means you'd have only a 2-week turnaround on that. That may not be very useful to you. So what we can do is we can give you your motion for discovery, which is granted, right? And this way give you time to get it. We come up with an appropriate timeline here. So April 24th is the soonest, or June 12th. Now take a look at your calendar, because I know definitely with district, I'm not trying to interfere with the felony matter. And Mr. Betts, you have cases of your own. So how does that look for y'all? April 24th or June 12th?
One thing I don't have, I think, on my calendar. So I'm sorry, Judge, you said June 12th. Friday, June 12th.
Yeah, so we get Fridays. That'll just be an FYI, guys. So, we got 5 justice courts. We're assigned Friday for criminal matters.
That is great for us because it's so hard to get heard on a matter that's set on Monday when you have to compete with these felony settings. But one thing, I know that Mr. Betts had been appointed. He just got appointed as a special prosecutor on a felony sex crime matter out in West Texas.
I mean, congrats on the special appointment, but that's subject matter we all know is tough. Okay.
Yeah, Mr. Betts, does that June 12th date, do you know if that conflicts with your appointment as the prosecutor on that sex crime case out in West Texas?
No, the April 24th did, but that does not.
Okay, June 12th?
June 12th, Judge.
All right, Mr. Blackburn, too. We do an announcement docket the Friday before, and that's all via Zoom, though. So the jury trial will be
so I think I may have messed that one up last time if we went in person and it was a Zoom hearing.
No worries. Yeah, we do the jury in person because I love Judge too, but he tried it once via Zoom and we're not doing that, y'all. We're not doing that, even on a court of record. We're just asking trouble there. But the announcement will do that via Zoom, so you can check in the week before. We do that on Friday. And then, yeah, okay, so June 12th. All right. And then just real quick, so we do give you a jury packet, but we do it the day of. We usually get about 22, 24 potential people for our panel. We'll give you that packet that morning. All the other rules apply. You get 3 strikes, all the same challenges and sort of things. So standard stuff.
Judge, we have a process where we like to ensure to make sure that our client gets a fair trial by doing a thorough analysis of the proposed jurors. And we have jury consultants that we work with that will do both a social media search and a social psychosocial history to make sure that there's not any conflicts of any witnesses having any connections with the prospective jurors. And so normally we request to receive that jury panel as soon as it's available. And most courts can accommodate at least 3 days.
All right, I'll see what we can do.
Thank you.
Yeah. We got a pretty good packet. Our district clerk, Velvet Price, is pretty, we're lucky. I will say that. And justice courts in other counties, they empower the clerk to go down and just pick people up off the street. And
I've seen
truly,
it.
y'all.
Yeah.
They just go down sometimes and pick up people who are waiting for magistration and say, hey, you get to be a juror today, and then stick them down. So at least we get a valid panel. And then Mr. Blackburn, usually we do about 20, 30 minutes. Mr. Mathis, I think you've been with us in trial. About 20, 30 minutes for voir dire, cover all the basic stuff. If you want to use examples, sometimes we get, you want to do your PowerPoint, absolutely fine. Last thing I'll give you technology-wise, we've got ClickShare. So I can't remember what we did down with the county at law district, but our method out here, if you want to bring like your own evidence of something that you've got, if it's something we've already got, we can display it for the parties. But it's a little USB dongle that plugs into your laptop. So if you don't have a USB port, we've got a thing. We've got some fancy new MacBooks coming that have no ports on them. And
I definitely use a PowerPoint in my voir dire, and then I also in my closing arguments I'm kind of old fashioned, and I'll bring a little printout of burdens of proof or what not guilty stuff. And so so you're saying that I can just that thing that plugs into my USB cord, it'll just talk through the Wi-Fi.
It's like a Bluetooth. You plug it into your computer, and then you turn on the little software, and you hit a button, and it just displays your screen directly to the projector for everyone.
That's awesome. That's great.
The only thing I caution that is if you like to communicate via Teams, put that on your phone. Otherwise, it'll be popping up, and it'll be like, "Hey, Ben, we've got a hearing. Judge so and so's calling." And you'll be like, "Wait, let me stop that. Let me stop that." Trying to think here, anything else that we normally do might be useful to know because it's just a little bit different. Well, also you guys will be first because it is from 24, so you don't have to worry about it. I also typically with justice court we'll set 20 for jury trial, and we'll maybe get 2 defendants, and then inevitably they take the plea. So you'll be reached. If there's any worry about getting reached, we'll have that.
Yeah.
All right.
Well, Friday trials are fun. We look forward to it.
And we get a pretty good turnout out here. I'm trying to think here. Jack, can you think of anything else technically wise that we need to cover? Only Mr. Blackburn, your counsel. So we get pro se parties who, we talk about voir dire and they just stare at me. You're prepared. I gotta think of anything else. Oh, so jury charge doesn't really exist for justice court. Essentially what we can do is we can give them a copy of the statute and they can take that back with them, but it's not, we just don't charge the jury in justice court.
So would it be all right with the court if I submitted a proposed charge?
We're not allowed to.
Like it's not permitted
prohibited
under
in the rules. Justice court doesn't charge. I know. We've even had it with 2 attorneys on both sides. And the best we can do is we can say, y'all can cover it clearly in your opening, your closing, and your question.
Yeah.
And then we can provide the jury with the statute and then with the evidence, but we don't, it's literally just jury finds in favor of the state or of the defendant, and then they assess a fine, and we give them the fine range, and that's it.
Okay.
It's de novo appeal, Mr. Blackburn. It's very specific,
right. So
very specific kind of thing.
Free bite of the apple. But I appreciate the attention to this matter today, Judge. And we usually have some other kind of like preliminary motions that we'll deal with at the docket call the week before, and I'll give Mr. Mathis plenty of opportunity to review those. And appreciate your time today, Judge. If there's nothing further, may we be excused?
Let's do one thing. Let's save Mr. Mathis for the discovery, 30 days from Monday.
Yes, Judge.
We could say 30 days from the order, but honest to God, y'all, we're getting a half off today and it's a holiday weekend. I'm not trying to put anyone through like, get out there, right? Mr. Blackburn, it looks like you may have already gone for Good Friday service. So let's say, by May 6th.
Yes, Judge. Understood.
All right. That works.
And just on that note,
a full month in to review it before jury setting and announcement. Yes, Mr. Mathis, what other things?
I just wanted to make sure, just before we all log off, I just want to make sure I have that down. So it's the radar gun calibrations for the radar system used that day by the officer, video of the gun being tested that day, copy of the operator's manual of the gun, and then any disclosure file stuff for the officer.
That's what I've got.
Okay.
All right, and then announcement will be a week before jury setting, June 12th.
Understood, Judge.
Y'all have a great weekend then. All parties are excused.
For a traffic ticket. What? What? No. Makes no sense. There's something else going on there. Something else. I got no clue what. Because I'm just your friendly little wolfie. I have no clue about those guys. I mean, guy seemed okay. So, client is a lawyer. I wonder if they're like in the same law office, possibly. Yeah, who knows? Chat, you've been wonderful tonight. You have been amazing. What can I say? How many things can I say about chat? How many things can I say about my friend Charlene, Steven Skyroot, X25, Julie Sassy, Sovereign, Legal Encounters, and Wixom? Unfortunately, Wixom, we're still not offering memberships here, but thank you for your donations tonight, your contributions, because, you know, without patrons like you, without viewers like you, there's nothing this old wolf could do. Oh, guys, it's been a long night. We're gonna go hang out with Hutch. I hope y'all are gonna go stick around. Go over there, give him a hard time. Well, don't give him a hard time. Just tell him I said hello. Tell him I said hello. Yeah, do that. But yeah, I'm gonna go over there. I'm gonna hang out and chat. I'm gonna listen for the most part. I've got some other things I need to do around the house here. The puppies have been up and about, and they've been a little bit of excited. The cat's been a little bit of excited. I think they've calmed down now. The kitty's over there on the floor looking at one of the puppy dogs like he's ready for round 2. Ladies and gentlemen, I need help. Somebody call the National Guard for me. The cat's driving me crazy before the end of the night. No, it's not that bad. But hey, I like to be a little dramatic. What can I say? Guys, I thoroughly enjoyed the Simpson block. I thought it was a lot of feel-good moments. What wasn't feel-good was a little bit of weird, and I like that a lot. The lease segment, oh wow, just a whole lot of, man, I just don't want to go to Kansas at all for any type of traffic. You know, I think driving through Kansas is like a, nah, thank you, no. I just, the possibility, I mean, just like getting a ticket and having to go to court for it. It's just weird. Hardcore. Of course, this old woofy hadn't had a ticket in a decade or so. Just find some wood to knock on here. Ladies and gentlemen, I'm going to say good night. Thank you very much. We plan to be here again at 11 a.m. Central Time. That's noon Eastern Time. For another live weekend court review. I'll be back. Hope I'll see you then. Thank you, ladies and gentlemen. I'll have a very good night. Don't forget Hutch. Don't just everybody leave and forget Hutch. And also, pro tip for the weekend upcoming here, those of you celebrating Easter, if you happen to see a rabbit laying little brown eggs, do not eat them. It's not chocolate. It's not.